talk, but I want to get right into it. We typically start with a land acknowledgement. We acknowledge that we are on the traditional indigenous homeland of Kalapuya peoples who were dispossessed on their indigenous homeland by the U.S. government and white settlers over several years, but most notably in treaties between 1851 and 1855. Kalapuya people were forcibly removed to what are now the Grand Ronde and Siletz reservations. They are now members of Confederated Tribes of the Grand Ronde Community of Oregon and the Confederated Tribes of Siletz Indians, and continue to make important contributions in their communities and across the land we now refer to as Oregon. We share this information out of humility and respect for this indigenous homeland and for the indigenous peoples who continue to live and thrive in what is now called the state of Oregon. And we make this announcement knowing that it's a first step. That is a first step, and you will see notices occasionally in our newsletter about things that are important to our indigenous people from our area here. Thank you. You have some cards on your table to write questions. Professor Epps is going to be speaking. We have about an hour, so write your questions down when you think about them. We'll gather them, and then he'll give us some time. Professor Epps, we are so pleased to have you, not just here in this room, but back at the U of O. I have to admit, I was pretty worried and a little stressed out about how to make this introduction. Your Wikipedia page reads like an encyclopedia. Do I mention legal scholarship, novels written, journals published in vastly impressive numbers, your amazing articles, your outstanding curriculum vitae? How about being legal affairs editor at the Washington Monthly? Well, to shorten things up, here's the word soup I created from an article by a colleague, Lyle Dennison, who I assume is also a friend, at least was before he wrote the article. He was bemoaning Baltimore's loss and Oregon's gain on your retirement in 2020. And here's my soup. Large, well-dressed, except for the boisterous ties. Gentleman, brash, acerbic wit. He was describing your naughty and irreverent side. Then he went on to say, sweet personality, up close, a friend who cherishes friends, elegant prose, wit and rumble, caring while demanding teacher, intellectually disciplined. I could go on. A warm welcome to our scholar and leading expert, Professor Garrett Epps.
Thank you. Thank you so much for that introduction. How is that sound-wise? No, not loud enough. I'm going to use this until you get that squared away.
That's not plugged in.
Oh, it's not plugged in. Testing, testing, testing. Is that okay? All right. Let's see.
Oh, technology. You gotta love it.
Okay. Chauncey, thank you for that introduction.
Yeah, I think you do.
Oh, I'm sorry. I'm sorry.
I think hand hold.
Yeah. Thank you. Thanks to the league for inviting me. Is this one off?
This one's off now.
Okay.
We're gonna keep trying.
I could shout.
You could.
I've been known to do it in class.
No doubt.
How is this? Any better? Yeah. Okay, good. I'm sorry for screwing the names up, but I have to say I'm very pleased to see Lyle referred to. Lyle is well into his 90s at this point and has covered the Supreme Court for longer than any human being in American history. And I liked him very much when I was the Supreme Court correspondent for The Atlantic because he was the only person I could go to in the newsroom who regarded me as the kid, you know. And I could go to him and I'd say, Lyle, tell me about Justice Douglas. And he'd say, well, Bill was a very smart man. You know, I mean, he had known a quarter of all the people who had served on the Supreme Court. So his praise is very sweet. I am thrilled and delighted to be invited back to the league. I have such a long history with this chapter. My friends Becky Gladstone and Ellen Maddox and others, and all the fine work that you've done. But it also embodies one of the things I learned at the very beginning of my career in journalism, before I was a lawyer. My mentor as a journalist was a man named Charlie McDowell. Some of you may remember him from Washington Weekend Review. And I got an invitation to speak, and I was like, the League of Women Voters, what is that? And I went to him and I said, Charlie, what should I do about this? And he says, son, don't never say no to the league. Now, as I look back, Charlie never explained the reasoning behind that rule, but I have tried to live by it, and I'm so flattered to be invited here. You've asked me to talk about the shadow docket. I have a pretty hard stop at 1, so I'm going to try to make sure to leave time for questions, which means hustling past such things as the difference between a writ of mandamus and the writ of prohibition. You can thank your lucky stars, because I can talk about that for an hour or two. What is the shadow docket? Now, here we have something that no one in this room, myself or anyone else, is really old enough to remember, and that's the 22-year-old Orson Welles in his first major role in show business as Lamont Cranston, the Shadow, in the old radio show, who would go, "Who knows what evil lurks in the hearts of men? The Shadow knows." And that laugh is what made him famous. The shadow docket, some of the justices object to that term because it makes it sound sinister. Others say that it is becoming sinister. There's always been a non-merits docket. The court has always needed to issue orders in pending cases or respond to emergencies like stay of execution, pleas, and so forth. But the shadow docket has begun to move and transform itself into a way in which the court makes merits decisions without revealing its reasoning or hearing full argument from anyone else. And this is a problem that is seen across the spectrum. This is not simply something that progressives object to. And we're going to take a look a little bit at how it works. Now, a week ago today, on Tuesday, this would have been the headline, or the headline a week ago tomorrow, of what happened a week ago today. Supreme Court won't hear new case on race and school admissions, and you probably heard or saw that. And this was important because it indicated that the court is not ready at this time to go further in its campaign to do away with any kind of race consciousness in education or any other area. That was important, but that was not the only thing that took place on that day on the orders list. And you can see 4 orders with separate opinions in very important issue areas, one of which, of course, is the affirmative action case, and that was highly visible, but the others didn't really make the news. And I will tell you that if you are a court watcher, if you are a lawyer that watches the court, if you are an activist, a Federalist Society person, or someone in one of the liberal advocacy groups, you watch this very carefully. We learned some things. Justices Sotomayor and Jackson have really got criticism of the court's death penalty jurisdiction. That's not jurisprudence. That's not news, but it's important to realize that they're not backing off the fact that they're always outvoted. Justice Alito, in a fascinating opinion, says that society is evolving in a way that he doesn't like, that people are criticizing people who criticize same-sex marriage and calling them bigots, and the court needs to move in and stop this. And I think it shows you something about Justice Alito's view of the court's rule. Justice Thomas is sort of out of the blue decided that the court needs to handle all economic regulation by states, and he wants to set aside New York's rent control law, which has not been the subject of intense litigation for at least 70 years. And then finally, Justices Thomas and Alito are not letting up on the campaign to take down all affirmative action. Those are important things to know, and they are announced only inferentially through so-called shadow docket orders. Now, what does an order tell us? Well, this is the important thing about the shadow docket. On the left, we see an order in a case called Texas versus Department of Homeland Security versus Texas. And this is the case in which Governor Abbott has moved the National Guard into the Texas border and will not let federal authorities and the Border Patrol fulfill their statutory and constitutional role of controlling the border. And the Fifth Circuit, which is the most extreme conservative circuit in the country, agreed. They said, that's fine, you can go ahead and do this, even though it contradicts every principle of immigration law. And the court reaches down and says that we are vacating that. That rule, the government may reassume, the federal government may reassume control of the border. And that tells us something that the order on the right doesn't tell us. The order on the right says that certiorari is granted in a death penalty case. So what's the difference? Well, the difference is that the order on the left required 5 votes to be entered. The order on the right requires 4 votes. Certiorari requires 4 votes. What that means is we don't know how the court is likely to rule in that case. On the other hand, this case, the federal side of this dispute has attracted, for the moment, 5 votes. And so the court is tipping its hand. And this nice young lady is competing in the World Series of Poker, and I'm sure doesn't tip its hand. But the principles, the factors that go into an order like that one are basically how likely do the justices think they're going to rule for one side. So it is a real signal of how the court will be deciding it. And not only that, it's a signal to lower courts saying we are coming for your decisions. If you go the other way, we will probably take them down. It's a very unusual form of communication between an appellate court and a lower court. They're supposed to hear the cases first, and the Supreme Court hear them at the end. The shadow docket, so-called, and this is a term Justice Alito objects to, but it was coined by one of the most conservative colleagues I have, Will Bode of the University of Chicago, who basically, not for ideological reasons, just thinks it's better if the court does its business in the sunshine. And these are just some, I won't go through all the statistics, but I can just say that just as one, in Chief Justice Roberts' first 15 years as Chief Justice, the court had granted 4 injunctions pending appeal, which is a very powerful form of shadow docket order. In the 5 months after the confirmation of Justice Barrett, it granted 6, and has continued at that pace to step into lower court cases and make its feelings clear. Now, these things happen without full briefing. They happen without oral argument. I don't know how many people have listened to any of the oral arguments now that they're online. I listened raptly to the argument about whether President Trump can be disqualified from the ballot, the arguments about Texas regulation of conservative voices on social media. These are really fascinating. There is no oral argument in a shadow docket proceedings. It's decided on a fairly bare bones record. It's called an application and a response. The lower court decision. Very little participation by amicus curiae, who are an important source of advocacy in front of the court. And they are decided very much along ideological lines. Now, the justices, when they speak, are always try to say, well, we're not really divided along. And they quote the numbers of merits cases that are 5-4 or 6-3. And they say, see, it's not so many. But if you add in the number of 5-4 and 6-3 cases, the number of cases driven by ideology on the shadow docket, and we don't know the full number because the court doesn't always reveal who voted how, It is quite clear that this is this explosion of shadow docket orders is coming from the newly empowered conservative wing of the court, which has 5 votes for the most ideological cases and 6 votes for just generally conservative cases. So the shadow docket consists of extraordinary writs, I will spare you what they are, summary decisions, grants or denials of certiorari, and stays in ongoing cases. It's important to understand what a stay means because people misread it. Sometimes when an application is received for an emergency order, the justice to whom it's submitted will issue an administrative stay, meaning the litigation's on hold for 5 days until I can get the answer. Or they will enter a so-called stay of execution. That doesn't mean you won't be killed. It means that the judgment of the court below cannot be carried out until the court decides the shadow docket order. An injunction is an order to parties. So when the court issues or vacates injunctions, that's a very powerful intervention. You may have won a judgment in the court below, and the court steps in and says, you cannot act on that judgment. That judgment is in abeyance. Certiorari, I think most of you know what it is. It is a writ. It sort of masquerades as a common law writ, but is largely a recent invention, meaning the court wants to take the record of a case and decide it for itself. You know, common law writs tended to be more fun than certiorari. My favorite one, which is unfortunately no longer issued, is the writ ad idiotam inquirendo, which was directed to the sheriff saying, go search out a named individual and see if he's really an idiot. And I think it's a proceeding that we could make good use of, but is no longer allowed. A writ of certiorari means the court's going to get full briefing, oral argument, amicus briefing, and conduct, reveal a full decision on the merits. On the other hand, the court can make a decision in summary fashion and simply say, we have a petition in front of us for cert, we grant cert, you lose. And that's the end of that case. And sometimes that's a good thing, and sometimes you understand why the justices do it, and other times you think, you know, maybe we could have talked about this a little bit. Grant, vacate, and remand is where the court grants cert, vacates the decision below, wipes it out, and sends it back to the lower court saying, you obviously didn't consider a recent decision that we entered. Please look at this issue again. And then finally, certiorari before judgment, which is the most dramatic order the court enters, is a case will be decided by the trial court, the district court. And the losing party in that trial, rather than appeal to the Court of Appeals, will go straight to the Supreme Court and say this case is so important that you should simply take it away from the Court of Appeals and decide it yourself. And sometimes you can understand why that would be the case, and sometimes you just don't understand why the court is making the decision that it is. But at any rate, that's those are the factors in certiorari. Now, an emergency stay, as I said, is different because it tips the court's hand, and you can see these are the factors the court is supposed to consider. And they all, basically the top 3, all are basically which side do we think ought to win. And it's a fairly, it used to be that irreparable harm was a perfectly workable legal standard because it meant something like, if you don't issue this order, I'll be executed tomorrow. But starting with the Trump administration's use of the shadow docket, which was much more aggressive than any other administration, the government began to argue that the government is irreparably harmed anytime it can't carry out a presidential policy. So when the border wall was halted because construction wouldn't comply with environmental rules, the government went to the court and said, we are irreparably harmed because President Trump wants to build a wall and he's being stopped. And the court said, you may go ahead with the wall. Now, bear in mind, the people who were suing were people whose land, including reservation land, the Tohono O'odham, Odom were going to be scarred and split in half by the wall, and their harm was not irreparable. Trump's harm was. So you can see that the factors have changed without really admitting it. Why has this happened? And there's a lively dispute about what it is. Some sort of defenders of the shadow docket say it's because lower courts are issuing more nationwide injunctions. I don't think the figures really bear that out. It is certainly true that when a district court decides to enjoin the government from doing its loan repayment plan or whatever nationwide, it does create a serious strain on the court system. District courts are supposed to be handling matters in the district. As I said, there has been a change in the definition of irreparable harm. That sounds like, you know, what happens when no one shows up for my class. You know. There is a claim by the conservative legal movement that the existing federal bench, when Trump became president, engaged in judicial resistance and were illegitimately trying to block the president's policies. By and large, from my own study of these cases, it seemed to me that the Trump administration was trying to do stuff that wasn't legal under the law as it was at the time, and the courts were just applying the law. But this was considered to be a kind of resistance that was illegitimate. We have to step in. Justice Thomas has actually written about this in opinions from the bench, saying these lower court judges hate the president and so forth. Now, as we move forward through the Trump years and into the Biden years, we have a lower federal bench that is intensely polarized. The Trump administration made good its promise to nominate extreme conservatives vetted by the Federalist Society to the district and circuit benches. They are entering some very novel orders, and this is producing crises in various forms of litigation. One reason that people speculate about is that we have a conservative majority. We have a 5-justice majority that comes out of the conservative legal movement, which is quite different from just being a conservative judge. Chief Justice Roberts, one of the most conservative judges I've ever met, but is not a movement conservative. He kind of just decides each case as it comes along. But with that 5-vote majority, they are eager to get things done. They know that they may not have it indefinitely. Someone might die. Justice Thomas is my age. Little known fact, and I'm running out of time, but I have to share this. In my youth, I was a reporter for the Harvard student newspaper, the Harvard Crimson, and one of the big high points of my career was covering a riot that broke out in Cambridge, Harvard Square, after a free Bobby Seale rally on Boston Common. The marchers who had a significant number of Panthers were involved, and they marched to Harvard Square, set fire, broke into some banks, and so forth. Years later, I was reading Justice Thomas's memoir, My Grandfather's Son, which is a very interesting book, and I commend it to people who want to understand something about the history of segregation and about this newly influential justice. But he writes that he was there. And he didn't quite say, I burned the bank, but he was one of the rioters. This was the high point of his black militant phase. And so I've always wanted to run into him and say, I know what you did. See what he has to say about that. And then some of it is that the majority is very committed. This court majority has strapped itself to the decaying corpse of the death penalty and is stepping in as much as possible to make sure that executions are carried out quickly and without a lot of legal foo-for-all. Criticism of it? Well, first of all, the Supreme Court was not, going into this period, the Supreme Court was not the most transparent part of government in general, we just don't know what's going on. And really, until the advent of COVID, you couldn't even hear the arguments live. You can read the briefs, you can hear the arguments, you can read the transcripts online, but traditionally that was not available. If you wanted to read a brief, you had to go to the court and say, I'd like to see the red brief in this case, and they would give you a physical brief, and you had to sit and read it there. So transparency is not the middle name of this court. The shadow docket makes it even less so, because we don't know what's going on. Often there's no opinion, so we don't know why the court has decided what it has decided. And quite routinely, there is either no notation of which justices voted how, or only partial. You may hear that 2 justices would have denied the order, but you don't know what the other 7, how that broke down. It disguises the polarization that I mentioned. The court likes to say, no, we're not ideological, we're not broken on ideological lines. The more you learn about what goes on in the shadow docket, the less credible that seems. We have an institution, and we'll study the reasons why in a minute, that is very intensely politicized and polarized at this moment in a way it has never been before. And just to give the top line summary of that, we have never before had a court where all 6 justices of one party are all on the opposite side of issues from all 3 justices of the other party. You go back to some of the earlier courts, and you usually had conservative justices like Justice Byron White or even Justice Powell, who would cross over and make coalition with Republicans. You'd have conservative justices who would make coalitions with liberal justices. We don't have that now. We have Republican judges and Democratic judges, and there's begun to be discussion in the journalist business where that maybe we should just say Chief Justice John Roberts R, the way that we do in the Senate. We don't know what precedent is set. Traditionally, it has been felt that a shadow docket order is not precedential. It just is, fixing that case for the moment. This court has taken a different tack and is now insisting that lower courts follow these brief orders and said, you have not followed our opinion. Some of the opinions they say were not followed have no content. And so the only thing that is communicated by this is, we told you which side should win these cases. Why aren't you getting with the program? That's troubling, because precedent used to be a really important part of Supreme Court practice. It seems to have, like a lot of other things, undergone some transformation. And then finally, it is part of a reduction in the court's actual merit docket. And this, I think, is an important thing to understand about the court, an important historical phenomenon, long antedating the advent of Trump or the Federalist Society, of the court's gradual transformation into a kind of institution that I think it was never foreseen to be at the time that it was set up in 1787. Now, a lot of there are a lot of scholars who will defend the shadow docket. They say that it is being criticized only because liberals don't like the court's results. I think numerically that really just doesn't stack up. And bear in mind that some of the critics are very conservative themselves, but believe that a court ought to act in a certain way. The national injunction we've discussed, and it is possible that we could alter the rules of jurisdiction to prevent this phenomenon. One of the proposals that's before Congress and eventually may be heard is that if you go to court, you go into district court and say, I want to enjoin abortion nationwide on the grounds that fetuses are protected by the 14th Amendment, or I want to enjoin the sale of mifepristone for medical abortion because I think the FDA is a bunch of quacks and I know more about science because I saw it on YouTube, If you want to do that under this measure, that case would automatically be transferred from the district court that you may have carefully picked out, right? Because believe me, these advocacy groups keep very detailed records about the district judges and how they're likely to rule. It would immediately be transferred to the district court for the District of Columbia, where the case would be heard by three district judges chosen by lot. So, you want to do it, roll the dice. You want to take it, but you're going to get a lot better treatment, a lot better consideration than some of these, the district court for the District of Buzzard Gulch or whatever, where people have only handled one kind of case or come out of a certain background or something else. There is finally this discussion that, and I had a conservative scholar say this to me, well, the justices think the lower courts are out of control. And that's the sort of judicial resistance argument again. My answer to him, which was, he's a friend and it was very cheerful, but I had always thought that courts were not supposed to be under control. They were supposed to be independent. And he's like, oh, Grandpa, get over yourself. Never mind the extraordinary writs. We do need a shadow docket, and here's an example. The two decisions at the top were issued on the same day. In U.S. and Danko Labs versus Alliance for Hippocratic Medicine, Judge Kaczmarek of the District Court in Texas ordered the FDA to revoke the certification of mifepristone and ban its sale nationwide, thus bringing to a halt the safe legal practice of medical abortion. The same day, a federal district court in the state of Washington issued an order to the FDA saying, don't you move a goddamn inch. You will continue to permit the sale of mifepristone until this issue is settled. So the FDA administrator is in a difficult situation and probably ought to stay out of Central Texas for a while. But the Supreme Court issued immediately, as it should have, a shadow order granting cert in the Texas case and barring the enforcement of this nationwide injunction. So mifepristone continues to be sold. Now, of course, we don't know what the court is going to do about it, but at least if the court does it, that's the Supreme Court and not some guy who, most of us have never heard of, and many of us who have heard of him wish we hadn't. So you need a shadow docket. On the other hand, the shadow docket can be abused. And here is an order in a case called Merrill versus Milligan. And this case concerned the Republican Alabama legislature's congressional district map that was enacted in 2021 after the census, and that was sued against by a group of black groups and plaintiffs on the grounds they claimed that it violated Section 2 of the Voting Rights Act by intentionally limiting the ability of black voters to elect candidates of their choice, that the legislature had intentionally split up black areas so that they were mostly in areas they were mostly in districts that were majority white, and since white and black is a very polarized voting phenomenon in Alabama, this meant that black voters who represent 25% of the population of Alabama would get only one rather than the 2 to 3 that numbers would suggest they were entitled to. This case was heard by a 3-judge court that included 2 Republican appointees, one of which was a Trump appointee. They heard testimony for weeks. They reviewed 40,000 pages of documents. And after that trial, issued a 131-page opinion stating that the Alabama legislature had violated Section 2 of the Voting Rights Act of 1965, one of the most serious civil rights statutes that we have, and ordering them to draw up a new district plan before the 2022 election. The state of Alabama went to the Supreme Court and said, we think we can convince you to just get rid of the whole Voting Rights Act anyway. So why not just give us an order? The Supreme Court, without any explanation, ordered a stay of the lower court's order. And what that meant was that the 2022 election for Congress in the state of Alabama took place under a map that had been adjudicated to be unconstitutional and a violation of the Voting Rights Act. Now, the court later heard the case and decided that they agreed with the district court. Great, no harm, no foul? Well, not really. Remember, the division of parties in the House is kind of dicey. And had that extra Alabama seat might have made even more of a difference than it did. The court stepped in to make sure that seat stayed white for the 2022 elections. The election will be held in the fall under a correct map, although you should be aware that the Alabama legislature refused to draw a new map when the court ordered it to, and said, we still think that the Voting Rights Act shouldn't be constitutional, so that the district court, the three-judge court, had to draw the map. That's abusive. That is abusive, to step in and permit, just as it is abusive to do something this court regularly does, and that is to step in to cases where a court of appeals has ordered a stay of execution of an inmate, stating this inmate has raised a serious constitutional challenge to the death warrant, either the method of execution or the jury instructions in his trial. These courts of appeals in the death belt, 5th Circuit, 11th Circuit, 4th Circuit, will issue orders saying this is a serious issue, do not execute this inmate until this case can be heard. The court will reach down and without explanation lift that injunction and permit the execution to go forward, even though a federal court has found that the inmate has a serious constitutional claim. That's abusive. Now, here we have our friend Hamilton, and I want to talk about what is happening to the courts and how the courts have changed since the framing of the Constitution. Now, Hamilton, bless his heart, I never actually thought of Hamilton as particularly musical until quite recently, but apparently he had quite a sense of rhythm. But I do think that Hamilton would have made the best possible auto salesman that you could possibly have. He's the kind of guy who would say, look, you don't need a backup camera because this baby knows not to hit a wall when you back up, so don't worry about that, you know, and you'd go away thinking, that seemed to make sense. He's trying to convince the New York legislature to ratify the Constitution. This is the Federalist being basically a set of pamphlets just aimed at one legislature. And he says, oh, you know, people are upset. There was no federal judiciary before the Constitution. People are upset that there will be all these federal courts, and they say that they will interfere and take power away from the people. Nothing could be further from the truth. And then he says, this is a famous thing, and it's always quoted back, the judiciary will always be the least dangerous branch. Why is that? Well, it has no influence over the sword or the purse, and it can't control the strength and wealth of society. It can take no active resolution whatsoever. It possesses neither force nor will, but only judgment. And that was an accurate description of most courts at that time, because courts, you open the courthouse, you sit there, and people bring cases, which you decide. Not generally known, but the first time the Supreme Court sat, it couldn't actually convene because they didn't have a quorum. The next time it sat, they convened and opened it, but no one brought any cases. So it took quite a while before anyone brought cases to the Supreme Court, and they waited and they decided the cases that came in. That's not force or will, but only judgment. The Supreme Court is no longer a court in that sense. And this is a long-term historical trend since the framing. There's no reason to really think that the framers understood the court as being as powerful a player as it is now, and the court does have force and will because it now can select its cases. And you can see that this is a long-term historical trend. The court was basically a court of appeals for most of the first century of its life. It got involved in some high-profile cases. You know, that Dred Scott thing didn't work out particularly well. But basically, they were taking the cases that came across the transom and deciding them. Starting with the Judiciary Act of 1891, the court began to expand, with the approval of Congress, the certiorari docket. This is where the writ of certiorari becomes important for the first time. In 1925, the so-called Judges Bill expands the writ of certiorari until it covers most of the courts, the subject matter that the court will hear. And in 1988, Chief Justice Rehnquist convinced the court, the Congress, that really the court needed almost complete control because the justices were so overworked. And we will see that. Now, you know, I always ask my students, you know, before I go to the next slide, what if you passed a rule that the DMV would only grant a driver's license if they felt like it? I mean, you could go in, you could apply, you take the test, and then the clerk would say, well, you know, I don't like your kind, you know. No license for you. Probably fewer licenses would be granted. Well, here we see the effect of these changes in the court's power of selectivity on its full merits docket. In 1891, it was deciding 301 cases. By 1988, that was down to 143, and the Chief Justice still insisted it was overworked. In 2022, 57. I'm not sure exactly what the justices do all day. They have clerks who do the drafting for them. But I do think that the small number of merits cases, in historical terms, that they're deciding contributes to these 200-page opinions that, you know, for my sins, I have to read. And I want to direct you to one particular figure, which is the total pages written in the 2022 term. The total number of pages written by Justice Thomas is 404 pages of opinions, either opinions of the court, dissents, or separate concurrences. Justice Thomas writes for the court less often than any other justice because, you know, he doesn't agree with anybody. I'm not sure he agrees with himself on some days, you know. And he wants to write long opinions saying we should overrule every decision. My favorite one is a separate opinion where he said we should get rid of these extreme principles that Madison had laid down, because Madison was an extremist. This is a hit with my students. Generationally, I don't know about this audience, but I always say that Justice Thomas reminds me of Vizzini in The Princess Bride, for those of you who've seen it, who says to the man in black says, you must be very intelligent. And Vizzini says, let me put it this way. Socrates, Aristotle, Plato, morons, right? That's basically Justice Thomas's approach to 250 years of jurisprudence by the court. He wants to overturn it all. The use of the shadow docket has split off Justice Roberts, the one non-merits justice, from his allies. He is the only one who will cross the aisle in these cases. And Justice Kagan, I really would urge you to avoid getting on the wrong side of Justice Kagan. It's a bad move. She is very direct in saying this is no longer a merits docket. This is just a way for the majority to get its way without explaining. And I think that there's a lot to that. Congress, you know, here they are in all their glory. They are discussing reforms like the one I talked about, but they haven't gone very far because not much can get done in this Congress. It would be excellent to consider certain reforms, such as a requirement that the votes be revealed, or, you know, a requirement that certain kinds of orders could only be issued with 6 votes rather than 5 to 4. It's not clear how the justices would react to those, but I think as I read the Constitution and the history of the courts, there's a lot that could be done by statute if Congress would just step in and say, you're not the third house of Congress. You are not here to pursue Justice Alito's vision of what society should be like. You're here to decide cases and controversies, and we are going to the extent we have the power, try to make you do that. One of the proposals that I'm very fond of, in part because it was brought forward by a fellow named Epps, but who is not me, is what he called the lottery docket, which is, the justices are just rattling around, writing 100-page opinions. Why don't we just have a lottery where they have to take, say, 50 cases from the lower courts that are drawn by lot? Not because they want to take them, but because, they get pulled out of the drum. Make them do a little work. I'm not sure that would do the country any good, but it would do my heart good, Anyway, that's an introduction to this topic. A lot of smarter people than I are working on it. It is causing a lot of discussion. There's some reason, as I say, as you saw from the quote from Justice Kagan, to think that inside the court, this is a matter of some concern as well. But with that, I'm going to stop and throw it open to your questions. And I'm sorry I talked longer than I should. Yes. Okay. All right. What is your best guess as how the court will rule on the Colorado disqualification? Well, I listened to that. I read the briefs. Among my other misguided efforts, wrote a book on the history of the 14th Amendment. I have pretty strong feelings about Section 3. But as far as I can tell, the chance that this court will issue a ruling disqualifying Trump is virtually nil. I counted 8 to reverse the Colorado court and 1 maybe to affirm. And what's interesting is that this court is not going to touch the issue of whether Trump is an insurgent. I think we all know that he violated Section 3. They're going to find other reasons why they can't decide it. And what's fascinating to me is that Trump's lawyer, a man named Jonathan Mitchell, and one of the, I listened, I was about halfway through this thing, and I said to my wife, what have they done with Donald Trump's legal team? Because Mitchell is a good lawyer. And he got up and made an argument. He basically conceded that Trump had no historical case at all. And he was going to base the entire argument on the text. And he said, well, first of all, it doesn't apply to the president. The president's not an officer of the United States. And secondly, and I love this one, when a student would come forward with something like this, I would, immediately just, embrace him or her and push them onto a clerkship or something else. He said, Section 3 says that no insurgent can hold office. It doesn't say they can't run for office. So why don't we see if Trump gets elected, and then we'll see if, And I thought, well, I didn't see that one coming. But the history is all on the other side. The court has made it clear that institutionally they don't want to be the ones that do this. Now, is that a valid, sometimes I think courts should say, here's what the law is, but, what do I know? But it reminded me of, I don't know how many people have seen Godfather 3, but there's a terrible movie, but there's a wonderful scene where Michael Corleone gets notified that somebody has whacked somebody, and he goes, just when I think I'm out, they're pulling me back in, right? And that was the air of it's like, what have we got to, leave us alone, for God's sake, you people fight it out. So that's what I think is going to happen. What do you think a possible dissent could be based on concerning presidential immunity? Some people are assuming a dissent is currently being written. Well, I tend to think the court is not going to buy immunity for presidents. I think they will write an opinion that says presidents have certain immunities, and then we're going to remit the case for proceedings to decide if Trump has those immunities. So I don't think they're going to say what the district for the D.C. Circuit said, which is presidents are not kings, a former president has no special immunity. On the other hand, I don't think they're going to buy what Trump argued. And, we all know that Trump's lawyer said in front of the D.C. Circuit that the president could order SEAL Team 6 to assassinate his political rivals, and there would be nothing that could be done except impeachment. And somebody pointed out, well, the president could also assassinate all the senators who would vote for his conviction. But the briefs in front of the court are more extreme than that, because they've left out the whole idea that impeachment could make a difference. They say presidents have to have complete immunity for separation of powers, and otherwise they won't defend America. And I don't think the court is going to buy that, because basically what you're saying is, court, you have nothing to do with this. And that's a mistake. I teach my students, always a mistake to tell a judge, oh, this case is not really before you. The judge is going to be like, Hoss, I'm going to tell you what's before me. And I think the court will dodge, but not completely. It will, however, delay the trial as the issue is litigated, and I don't anticipate there'll ever be a full verdict in the insurrection trial. I'm not sure any of these criminal proceedings is ever going to proceed to judgment. That's certainly what the Trump lawyers want. But I think that's, if there's a dissent, it's Thomas. You can imagine Thomas saying, yes, presidents should be completely immune. About the court's ethics, yes, there's an apocryphal story about Gandhi. Probably didn't happen, but it could have, in which a New York Times correspondent says to him, well, Mahatma, what do you think of Western civilization? To which the Mahatma replies, I think it would be a very good idea. If you want to ask me about Supreme Court ethics, I think that would be a good idea. This court is ethically compromised in the most humiliating ways. It's not simply the porousness between the right part of the bench and the political movements. It's literally taking money, which, I always thought that was a no-no, right? When I was a reporter for the Washington Post, I used to take federal judges to lunch, and they would say, I have to pay. I can't take lunch from the Washington Post. Apparently, the rules are different. In fact, we know they're different. There has been no code of ethics at the Supreme Court level. What's fascinating is that the Chief Justice, who has fought against this for nearly 15 years, has finally given way and allowed the court to enact a largely toothless, but nonetheless symbolically important code of ethics. It doesn't say you can't take an RV from your buddy, but it does say that you should not do things that would have your impartiality called into question. So I suppose that's progress. I think in any other period of American history, Thomas's resignation would have been on the chief's desk 2 years ago. It's just shocking to me. Shocking, and that's a word that can be overused, but not in this case. Shocking that a United States justice would behave in this way. And, the misbehavior is continuing. So, I think it would be a very good idea. Yeah, I got time. Yeah, will do. Do laws regarding changes proposed for SCOTUS need to have a super majority? I'm not sure what the question asks. I mean, formally, no, but, we do have the filibuster in the Senate, which means that no measure can be debated in the Senate unless 60 members of the Senate agree. And so I don't think any serious reform to the court will get through Congress unless 60 members of the Senate are behind it. The biggest obstacle right now is the House. I mean, I'm not sure this House of Representatives would enact the Boy Scout law if it came in front of them. They just can't agree on anything. So the possibility of change is in the at least middle distance and perhaps far off.
He says, given their rulings,
Mm.
isn't it a good thing? That they only have two cases.
Well, I would,
You're going to need to repeat.
this is given their rulings, isn't it a good thing that they only take very few cases? Well, the problem with that is that they take the cases that they really care about. And as long as that is within their sole discretion, I think a lot of us are going to have some serious objections to the shape that our jurisprudence is taking. On the other hand, I always like to quote Chief Justice Roberts in the years before he became Chief Justice. He was in the White House counsel's office in the Reagan administration, and he was writing about a proposal to create a National Court of Appeals, which he was against because he said some Democrats may be on that Court of Appeals, and our Republican control of the Supreme Court is better. But then he said the other good thing about the way the court operates now is that the term ends in June, the justices leave town, and the Constitution is safe for the summer. I haven't asked him if he has re-examined that view, to paraphrase an old saying, no man's liberty or property is safe while the Supreme Court sits, and I'm in favor. The Jeffersonians, when they took over in 1801, passed a law abolishing the next two terms of court so that the court couldn't meet until 1803. That sounds good. Okay. What are some issues likely to be decided in this fashion? Well, birthright citizenship, I don't know. I mean, that's the thing. There's no real upper limit. I think if, in fact, Trump becomes president, and if, in fact, he follows through on the pledge to try to end birthright citizenship, 14th Amendment birthright citizenship by executive order, that case will eventually be decided by the court. It's just not going to be, relegated to a lower court. Now, the question is, what if some circuit court is going to say, dudes, I read the 14th Amendment the other day. Have you ever read it? It's kind of cool. And it says birthright citizenship is right there. So, no, you can't do that. When that is appealed by the Trump Solicitor General's office, will the court step in and stay that order? And that's a really important and very ominous sign if they do. I tend to think the court won't go for this. I think it's a bridge too far. On the other hand, one or two more appointments, who knows? Okay, let's see. What are your top three recommendations for fixing the system? Well, I was saying at lunch that I have friends and family members who are very involved in reforms to the court. I'm kind of more of a I don't like candles. I just curse the damn darkness. And my mission is to say to people, what's going on is not normal. This is not the way the court should be operating. I would like the justices to take seriously their historical role. That's not going to happen. So how do we rule them? How do we rein them in? I think the D.C. Circuit, the D.C. District Court proposal for nationwide injunctions is a really good one. It is said that if the Congress passed a law saying the court must reveal the votes, that the court will simply start saying all these orders are unanimous, even though they're not, because it would be resisting interference by Congress. And remember, Justice Alito has already gone public and said Congress has no power to regulate the Supreme Court. We can do whatever we want. I think that's historically ludicrous, but I think that is a view that, he's not the only one on the bench who shares that. So Congress has to be really careful and move step by step so as not to push so far that the court issues a ruling taking away Congress's power to regulate its jurisdiction. Yeah. Oh. Are you talking about the disqualification case?
Current status on Colorado versus Trump on the ballot?
Yeah. Yeah, that's a case called, I think it's called Trump versus Anderson. And that is before the court. That has been briefed, fully briefed, and argued. When? I think it was about 3 weeks ago. And the court is now considering it. Yeah, yeah. The court has it. All the briefing, everything's, it's all over, except shooting the dogs, and we'll find out what they do when they issue an opinion. Very interesting to see how quickly they'll move, or whether there's an attempt to slow things down from inside the court. We will only be able to guess. A lot of court watching is a little bit like if you've ever read the story of the discovery of Pluto. These astronomers kept saying, Neptune and Uranus move in this weird way. It's almost like there's something out there. And then they started looking and they found this tiny little planetoid. You kind of do that kind of thing if you're a Supreme Court journalist or watcher. Why has this taken so long? Why, for example, did the Dobbs case get relisted 15 times, longer than any other case, or except one, in court history, while they waited for Justice Barrett to be confirmed so that they had the votes to overturn Roe versus Wade? Well, you can figure out what was going on, but you don't get confirmation, right? You never spot Pluto. You just see it out there, its effects out there. So that's the question, is when is it going to be decided? When will it be released? It is the merits are before the court. The court granted cert almost immediately and heard the case on an expedited basis. God bless them. That's what they're supposed to do, right? When the election is pending, they're going to decide that, I hope, in time for ballots to be printed properly and so forth. I don't see much prospect that Trump is going to be disqualified.
Good question. Thank you.
Yes. Thank you, everybody.
I have a small gift that I'm going to hand him as he goes out the door.